everyone. Good afternoon. We're going to get started right away now. And I just want to let everyone know that this webinar will be recorded and will be available for viewing later. You may ask any questions at any time using the chat box in the lower left-hand corner. We will read your questions out loud at the end, depending on the amount of time that we have, and the presenters can then answer. And without further ado, I'll hand it over to Loretta Robertson.
Hey, good afternoon, everybody. I think it's afternoon for everyone. We have quite a few people on here today. So we're going to go ahead and get started. We are having a couple of technical difficulties, but hopefully we're going to be able to get our DOL partners on the line here fairly soon. So for today's agenda, we're going to be going over the highlights from the May 15, 2017 memo that was sent out. That was part 2 of the Q&As for the reporting measures. We're also going to be speaking later on, as soon as we can get our guest speakers on the phone, about the use of unemployment insurance wage information, and hopefully we'll be able to get Pam Mertens and Agnes Well on the line to join us to speak on that aspect. So regarding the suggested template, in that May 15, 2017 memo, we included in attachment 1 a suggested template for the annual report. And we highly suggest that states utilize this template. However, if states choose to use another format, that's all right, but they must ensure that all of the elements that are shown in that template are included. And in the next few slides, I'll highlight a couple of those elements. So as we all know, the first report is going to be due January 1st, 2018. One of the things that I really want to emphasize here is that annual report will be sent to your regional office contact, just as your state plan is sent now, but also you're going to send a copy of that annual report to the national office, which is using the SNAP E&T reporting measures email address. So regarding the suggested template, here is an excerpt from that template. This depicts the national reporting measures for the unsubsidized employment and the median wages. A couple of the things that I want to highlight here is please note that in addition to the percentage and value and the numerator and denominator information, we are also asking that you provide what the data source was that you used for that specific measure. For example, quarterly wage records. The next slide depicts what the disaggregated characteristics shows for those national reporting measures. So for this one, it's, as you can see, it's the unsubsidized employment in the second quarter. Again, just like the national measures, we also want what that data source is that you're using for that. Also, one of the things I wanted to highlight here is that you'll notice that for the characteristics of received high school diploma or equivalency prior to participation in E&T, we also included a line that is said educational level is unknown. So in those instances where you just don't have the information for participants, or maybe you had made modifications to your system and you don't have it for everyone, you can record that for those participants where you truly do not know what their educational level was. For this screenshot, this is the median quarterly wages in the second quarter. One of the things I just kind of wanted to highlight here is that, of course, for the disaggregated characteristics, this is going to share the same characteristics that you would be reporting for those individuals that were in your second quarter employment. So let's talk about unsubsidized employment and the earnings measures, and specifically who is considered a participant. So someone who is placed in and begins an E&T component. This would include an individual who intends an orientation or undergoes an assessment, even if they do not subsequently begin an additional E&T activity. That's because we consider an orientation or an assessment is considered part of the component to which the individual is assigned. I want to highlight too that it would not include, in the case of a mandatory program, this would not include individuals who are referred to an E&T program, but they never show up either for an orientation or an assessment or for the first appointment. Okay, so for the next, we wanted to highlight the clarification that we issued in the Part 2 Q&As regarding completion of E&T as it relates to unsubsidized employment and earnings measures. As the Q&As indicated, what we've done is we have aligned the definition of completion of E&T with the WIOA definition of exit. And so state agencies must use a 90-day look-back period to determine when an individual has completed participation in an E&T program. So what this means is that agencies will use 90-day look-back period to determine when an individual completed participation. If the individual has not received any E&T services for 90 days, excluding the provision of job retention services, then the individual is considered to have completed participation, and the last date of service becomes the trigger to begin the clock for your second and your fourth quarter employment measures. And I think the next few examples will help kind of illustrate what we mean by that. So for this, we have a 90-day look-back period example. We have Joe, who begins participation in June of 2017. He stops participating in August of 2017 for whatever reason. So you're going to look to see in the month of September, October, November, if there were any E&T services received. If there were no services received during that 90-day period, then you're going to go back to the last date of service, which is August of 2017. And again, that becomes your trigger as to when you'll start then beginning to track their employment information. So for the next example, we have a 90-day look-back period where there is a break in participation. For this example, we have Billy Bob, who begins participating in February of 2017, and he was enrolled in an educational component in April of 2017. However, there's a break in May that occurs for whatever reason because he's waiting to begin the next course. He resumes the educational component in June of 2017. So even though he had a 30-day break, he is not considered yet as having completed participation in E&T. So things just go on with him until, again, a 90-day break has occurred. So in this next example, we have a participant who has returned after 90 days. Using the same example as Joe earlier, where he completed services in August of 2017, being his last date of service. There was a 90-day gap, but he returns to E&T in January of 2018. What you have here is then, because a 90-day gap occurred, what's occurring is you'll have a second period of participation. So you'll track employment for both of those periods of participation whenever he completes the services after that 2018 return. So after that, now let's talk about your tracking of your unsubsidized employment and the earnings. Now that we've determined that an individual has completed participation in ENT by establishing the last date of ENT services, let's talk about tracking the employment measures. As we all know, those are going to be tracked quarterly, and the quarters are broken into 3-month segments based on the federal fiscal year. Using the prior example of Joe, because August 2017 was established as his last date of service, you'll be looking for employment for the 3-month period of January 2018 to March of 2018. That would be the second quarter after completion of participation in ENT. Likewise, for the fourth quarter, you'd be looking for employment that is within the quarter of July 2018 to September of 2018. We have another example here where Sue has completed participation. Her last date of service in ENT is in February of 2018. So you'll be looking for employment that occurs between the quarter July 2018 and September 2018 for the second quarter, and then the fourth quarter is January 2019 to March 2019. All right, so I don't know if you can this projects very well, but what this is demonstrating is for using the quarterly wage records that comes through the unemployment insurance information, because there is a 6-month lag time, we wanted to depict when those wages would actually be available in the UI, through the UI wages. So if you have someone who completed participation in quarter 1, again, which occurs between October and December, the wages you'd be looking for would be between April and June. They'll actually appear, or you'll be able to gather that information through the UI system then in between October and December of 2017. Okay, so regarding the national measure for component completion, this national measure for completion of an education, training, work experience, or on-the-job training component truly means completed. So it's not like the employment measures that are looking for, quote, the last date of service, and if there's a 90-day lag time. What we're looking for is someone who actually, they began one of these activities and they saw that activity through to the completion. So for an example, a participant who begins an educational component that is slated to last 6 weeks, but they only participate for one week, they would not be included in the completion of this component. So regarding the calculation for this measure, it only includes education, training, work experience, or OJT. It does not include other components such as job search training, or work fair. It is a duplicated count, meaning that you're going to count a participant for each activity that they complete within these activities. So if you have a participant who completes education and work experience, you're going to count that individual twice. So it is going to be a duplicated count. The denominator for this measure is all participants in the reporting period that began an educational, training, work experience, or OJT component. And then the numerator are those participants who completed those components during the reporting period. This may not reflect very well on your screen, but this is the national reporting measures, the denominators and numerators, and I hope it displays all right. However, it is shown in the Q&A document, Part 2 Q&A document as Attachment 2. So I'm not going to go over this. I think it's detailed well enough in the Q&A document. So we'll talk about the participant characteristics for a minute. The biggest thing here is that it's reported for all participants at the time they begin an E&T program, regardless of their participation duration. So individuals who are referred but who do not show up for their first appointment would not be considered an E&T participant, so they're not going to be included in the participant characteristics. If you have individuals who attend their first appointment, such as the orientation or the assessment, but they do not return, they would be considered an E&T participant, and you would include those individuals. For this measure, it is an unduplicated count, so participants who complete E&T services and return during the same reporting year, you're not going to report those individuals twice. You're only going to report them once during that reporting year because it is captured at the initial point of referral, the first referral into E&T for that reporting year. All right, regarding the state component measures, it is an unduplicated annual total. An individual who participates in job search for 3 months would only be counted once in that component. So for an example, you have an individual who participates in job search for 3 months, you're only going to count that individual once. You're not going to count them 3 times during that reporting year. We had received a question about what happens if a state actually serves more individuals in a component than they had intended to, or that they had indicated they intended to in their state plan. Would they be expected to report that component? No, you would not. We would not expect you to report that component in that year. However, we would expect you in subsequent state plans or annual reports, we would expect you to include a reporting measure for that component. And so we'd be asking you to include a reporting measure in the following state plan. I think we're going a lot quicker. Okay. So do we have our, no. Okay. I think we are still trying to get our DOL reps on the line, so I think I will go to see if I've got some questions that I can answer. Okay.
Yeah. DOL is actually on the line. We were having some issues, but it looks like we're in now. Can you hear us?
Hello, Agnes and Pat, do we have you on the line?
We are.
Hello.
Great. Glad we found you. You're now talking to the whole group.
Great.
Oh.
Hi, everyone.
Hi.
Agnes is going to do our presentation today and just give you some brief information about confidentiality of the wage records and what the state UA agency is required to do with respect to getting you all involved so that they can get you the data you need for reporting purposes.
Okay. Hi, everyone. Thank you so much for inviting us to this presentation. We want to share a little bit about the confidentiality of UC information and what our regulation requires and what it permits as far as the disclosure of confidential UC information. The confidentiality and disclosure regulations at 20 CFR Part 603 govern the protection and disclosure of confidential UC information by states and state UC agencies. And when we say UC, we are referring to unemployment compensation. Section 603.4 of our confidentiality regulation requires that state laws provide for maintaining the confidentiality of any UC information which reveals the name or any identifying particular about any individual or any past or present employer or employing unit, or which could foreseeably be combined with other publicly available information to reveal any such particulars. UC information includes any information that a state UC agency collects in the course of its administration of the state's UC program. So this includes employer information, wage information, claims information. So pretty much anything that a state UC agency collects in the administration of its UC program is considered to be UC information, and it may not be disclosed by states except as permitted by the confidentiality regulation. There are certain mandatory disclosures and certain permissive disclosures that are outlined in the regulation. One of the mandatory disclosures is disclosures to various federal government programs, including temporary assistance for needy families, child support enforcement, housing and urban development, the Supplemental Nutrition Assistance Program, of course, and the Railroad Retirement Board. So the disclosure of confidential UC information to these various federal programs are for eligibility purposes. So those are required. States are actually required by federal law to disclose that information for the eligibility purposes for those various federal programs. The regulation also outlines certain disclosures that are permitted. The regulation permits disclosure under certain circumstances as long as the disclosure does not interfere with the proper and efficient administration of the UC program. And the permissive disclosure that we are interested in talking about today has to do with disclosures to public officials. And that information should be on the slide there. Let's see here. There it is. Very good. Under 20 CFR 603.5E, the disclosure of confidential UC information to a public official for use in the performance of his or her official duties is permissible when authorized by state law. We define public official as an official agency or public entity within the executive branch of federal, state, or local government who or which has a responsibility for administering or enforcing a law. State SNAP agencies are considered to be public officials under this definition. State SNAP agencies are required by law to collect certain data for the SNAP ENT outcome reporting measures. So by disclosing confidential UC information to a state SNAP agency, which is a public official for the purpose of administration and execution of the law, that is a permissible disclosure. So we want to make clear that the type of disclosure that SNAP ENT is seeking is permissible. States are permitted to do this. Let's see here. Oh, yes. State SNAP agencies should already have an agreement in place with the state UI agency for the required disclosure, the eligibility-related disclosure that we talked about a few minutes ago. That agreement may be amended for the SNAP ENT outcome reporting purpose, or a new agreement may be crafted according to, whether the state would prefer a new agreement.
Right. One of the things that we don't know about in individual states, this is Pam, that is that under the income and eligibility verification system, which is the eligibility requirement provision that Agnes was talking about, the states may have, the state UI agency, UC agency, may have a separate agreement with each of those required disclosure entities, TANF, SNAP, HUD, those other agencies that are required to participate in the income and eligibility verification system. Or they may have, in any given state, they may have one agreement that all of those required programs have signed on to. If it's the latter case, then it may well be that for this new purpose, that because the agreements are required to include a purpose, and so when you have a new purpose like this, they may want to have a new agreement because clearly this purpose is not related to the income and eligibility verification system, so you wouldn't want to tack on a new purpose to that, but it's a separate purpose, and if the state has an agreement with just SNAP for the income and eligibility verification system, then it may be okay to tack this new purpose onto that because you all are the state SNAP program would be the only entity signing onto that besides the state UC agency. So that's really what we would suggest that you talk to with your UC agencies. And if you're having questions about that, certainly you can contact Agnes and me. So have we lost somebody out there?
I hope not. If you have any questions or if you're unclear on anything that we just said, it was a lot of information in a very short period of time. So please let us know if we can clarify anything for you.
Also, Agnes, what's our joint guidance people number?
Teagle 07-16.
Yeah, we issued some joint guidance with the Department of Education, but at the reason that I wanted to raise this with you all, and we can go ahead and send it to Loretta, there's a list on there of as an attachment of every state agency, UI agency, UC agency, and who in that agency is responsible for agreements. And we can go ahead and send that to you all, and you can send it out. But that will give you all information on who to contact and how to contact them. If you don't already know who in the SNAP office, in your state SNAP office, has the agreement for the required disclosures under the Income and Eligibility Verification Act system.
Okay, yeah, this is Loretta, and yeah, we can definitely send that Teagle out to everybody, to all of our state agencies.
Well, the Teagle itself may not be necessary.
Yeah, just because that addendum to it would be a useful resource.
Yeah, because the Teagle itself has to do with FERPA and education and how they can disclose information to the state UC agency.
Okay.
And it's broader than that, really, but it kind of gets bogged down in that, and I wouldn't want you all to get bogged down in that.
Yes, please.
because I don't think that would be helpful.
We don't want to get bogged down either. So.
Right, but certainly we can send you that attachment, so that just that list, so that you would have that, because that would be very helpful, I think.
Yeah, and if I recall correctly, it's been a while since I've looked at it, but in most cases it is the state UC agency that you would be contacting, but there are a couple of states in which it's a different agency that handles the data sharing agreements, like perhaps the Department of
Administration
or Commerce or some other agency.
Right. But at least you would have that, and it has links in there to the contact agency. Is that right? Yeah, so we have links in there, and so if we send it electronically, then the link should show up, but that and that's the best information that we had as of last July, because that's when we issued the guidance, was last July.
Yeah.
So I think that would be helpful to you all.
Yes.
Okay. We have a couple of questions that maybe you can answer.
Sure.
What's that?
One of the questions is Department of Labor also required to disclose information to the Energy Assistance Program?
No, that's not one of the required disclosures. The required disclosures they've been enacted by Congress over the years, and different ones were added. But in our regulation, if you want to look it up, it's at 603.6, and that has the required disclosures for a lot of the different programs. And with respect to SNAP, to food stamps, what it says is that, and it's also in Section 303D1 of the Social Security Act, which would be 42 USC 503D1. Okay, so that's the statutory requirement, and then it's incorporated into our regulation at 603.6.
B3.
B3. I'm trying to follow down here to see the subsections and stuff. Okay, so it's in 603.6 B3, and it requires each state UC agency, for purposes of determining an individual's eligibility benefits or the amount of benefits under a food stamp program established under the Food Stamp Act of 1977, to disclose upon request to officers and employees of the Department of Agriculture and to officers or employees of any state food stamp agency wage information and whether the individual has received or will be receiving unemployment compensation benefits, the current or most recent home address, and whether an individual has refused an offer of employment. So those are the things that under the income eligibility verification system that the state UC agency, the Unemployment Compensation Agency, has to provide when the SNAP program requests information for a given individual. And usually I suspect that this is batch processed or that it's electronically handled, so that you can just, sometimes states put out certain screens, and it depends on how the state handles things, but you send a Social Security number and that information comes back to you. So that's for the income eligibility, but that is not the same as the this other program,
the Energy Assistance.
The Energy Assistance
now
program.
Now we are not familiar with the Energy Assistance Program. Is that also run by the SNAP agencies?
I'm not sure that I can speak to that either, frankly.
Okay.
I mean, it may be. I'm not sure why the question was about the.
Okay, because the reason we say that is it's not a required disclosure under our regulation. However, if the Energy Assistance Program is run by a public official as defined in our regulation, then it would be a permissible disclosure. The state may disclose that information for the purpose of determining eligibility for the Energy Assistance Program, so long as the recipient of the confidential UC information meets the definition of public official.
Right. Okay. Another question that we had was, who decides what is permissible? They assumed that it would be the Department of Labor, so may they also refuse to provide the data?
Yeah, they can. For permissible disclosures, first of all, let me tell you that our regulation provides the minimum level for confidentiality. Some states have more restrictive laws than what our regulation requires, and that's okay. We tell states you can be more restrictive. You can't be less restrictive with your data. But whether a disclosure is permissive or mandatory is set out in the regulation. Permissive disclosures are at 603.5. and required, as I pointed out, are 603.6. So, and the required disclosures have been enacted by Congress or set out in other regulations. Because, for example, when the Workforce Innovation and Opportunity Act, the new one, I'm sorry, WIOA was enacted, but we amended our regulations at that point to make sure that those disclosures for the WIOA programs could be included, or that states would understand that they would be included in the permissive disclosures under 603.5E.
Yes.
So that's, but who decides if it's permissive? The regulation says what is permissive, and we also say that to the extent that it does not interfere, that first of all, state law allows for it, and secondly, that it does not interfere with the efficient administration of the UC program.
Right.
But if you all are having a problem with a state, please let us know.
Yes.
Okay. Another question that we received is, does the term, or do public officials include, or does it extend to the contractors or the grantees of the state who operate the ENT program?
Yes and no. I would say yes, because if you look at 603.5E, that refers to the public official, but 603.5F refers to the agent or contractor of the public official. So when the state unemployment agency is entering into an agreement, their agreement has to be with the public official, but the agreement provides for the disclosure of information to the contractor, and that's quite common.
Okay. All right. So, I mean, I think bottom line is that, I mean, the lesson here is that the SNAP agencies need to really work with their Department of Labor and or the Unemployment Compensation Agency regarding the amendment, if that needs to be updated or amended to include SNAP ENT. They also need to, see if there are more restrictions at the state level than is placed on the federal level, and see
and the state UC agency will tell them that, Loretta. Mm-hmm. So if, for example, I mean, some states, for example, New York, has very specific provisions about who may obtain data. And over the years, they have expanded that, because at one point they couldn't even give it to education entities. But now they've expanded those, but sometimes they still don't have the specific language that they feel would allow them to do this. But as I said, because the SNAP agency is a public official, this is the performance of public duties, and so we do not see that there would be any problem in any of the states with specific disclosures for this program.
Yes.
Okay. All right. Yes,
Okay.
And in the case of New York, I know that they're working to try to add or include ENT as in their state statute as a permissible. Okay, so are there other questions regarding specifically about the use and collection of the employment information from the UC system? I haven't seen any of the last couple of minutes, so.
Okay, but if anything comes up after this webinar, you have our contact information. Send us an email, and we'll do our best to get you back an answer as soon as possible.
Right. And I just put up the kind of the resources page, and that has the state plan handbook that has our information about reporting measures, as well as the link to the interim rule, which contains all of the guidance that we've issued to date on this topic. And then here's our contact information with Pam and Agnes's email address. Let's see. Sorry, I'm manipulating the system here to make sure I don't see any other questions. Okay, so I think we have a few minutes. I'll try to go back and see if we've got some other questions that we can answer. I will tell you, looking at them earlier, I know that there are some that we're going to have to take some further time to research and investigate, so I may not be able to answer everything that's been submitted today, but we'll try to get you.
Okay, Loretta, do you want us to stay on the line, or do you?
No, I think you can. You're more than we can let you go.
Okay, I just wanted to make sure.
We will send out this information as well as the reference that Pam and Agnes referred to earlier. As soon as we get that, we'll send that out to everybody who had registered for the webinar. So I appreciate your time today, Pam.
You're welcome, and we're more than happy to help anytime you need us.
Thank you.
All right, thanks.
Bye-bye. Bye.
Okay, so I'm going to go back and try to answer a couple of questions here. One of the questions is, what information goes into the value field of the template? So the value would actually be what is the value of the calculation for whatever the measure is. So it's the sum of the numerator of the denominator, what the answer is there. So, for example, if you have 100 people that you have 100 people that are in your reporting period that completed ENT services during the reporting period, and 10 of them had employment in that second quarter, then you have a percentage or a value of 10%. So 10% would go into that field. So another question is, if we use the same case management system as the Title III for our ENT program, is there any issue using the wage information available to compute the ENT outcomes and only report out in aggregate data? So your Title III system, are you talking about your eligibility system? Can you clarify what you're talking about here, what you're using? So we have another question. So to confirm, we're just expecting to report on 1 quarter of exiters for the second quarter employment measure for this first annual report. In essence, yes, if you are using quarterly wage record information, which we have indicated is really the best source to use and the preferred source to use, then really the only people that are going to show up because of the lag time of when the UI wages information is available is more than likely only going to be those individuals that completed participation in that first quarter of 2017. This is going to be kind of a rolling report, so you would report on those individuals then for the fourth quarter in a subsequent report, in the 2018 report. Question is asked, are we going to send out this presentation? Yes, we are going to send out this presentation as well as any other source documents, such as the one that DOL, Pam and Agnes referred to. And also, we are recording this, so this will be available, a link to this will be available at some point as well. Okay, we had a question about how would a state determine when an individual is participating in an educational activity that does not have a specific durational period has completed. For example, a participant is engaged in adult basic education classes. I mean, we would hope that you would be getting that information from the ENT provider as to when they've completed participating in that activity. I mean, that would be the best source would be actually from the provider who's providing the service. Okay, I think that's about all of the questions, unless there's any more questions that come in. Someone asked if there will be a non-PDF format for this, for you to enter data in the annual report. Yes, we will provide a Word document for the template if we haven't already on our website. So we'll make sure that that gets out to our regions and out to our states. Okay. We had a question about if a participant isn't assigned a component until after orientation, how will the state know which component to count the person as having participated in? So I'm guessing that you mean that they have come in for the orientation or the assessment, but they don't return for, I mean, at that orientation or the assessment, you would hope that they would have, that the ENT provider or the contractor would determine what service is the service that individual is going to be placed in, and that's what you would report them in. Whether that's going to be job search or whether they're referring them to training or education. So, I mean, really the point of the orientation and the assessment really is to kind of establish what that plan for services is and what that path for services is. Okay, I think that's all we're going to be able to answer right now. We do have these questions, and we'll try to get back to the individual who asked the question, but they do take a little bit of some research or some further policy discussion here before we can answer them. So I think we are done. We appreciate everybody's time, and again, it could be expecting this information to come out via email.